If you have been served an order from a safety codes officer or a written notice refusing, suspending, or canceling a permit, design registration, accreditation, certification, or designation of powers, you can appeal this decision to the Safety Codes Council. Our appeals process is fair, accessible, and allows all parties to be heard by a tribunal made up of independent representatives of Alberta's diverse industries and regions. In order to properly file, prepare, and present your appeal, there are some key things you should know. First, let's talk about the people involved. The two parties to any appeal are the appellant, the person who is appealing the order or written notice, and the respondent, the person responsible for issuing the order or written notice. The coordinator of appeals is a council employee who works with all parties to ensure the process runs smoothly from beginning to end. An administrative tribunal is assembled by the coordinator to hear and decide an appeal. The tribunal is made up of at least 3 individuals with the experience and knowledge to help make a decision in the case. Both parties, as well as the council, have the right to hire legal counsel to help with any and all parts of the process. But representation is not necessary for an appeal to proceed. Now that you know who all is involved, let's talk about how to prepare for your appeal. The appeals process begins when the appellant completes our Notice of Appeal form and files it with the Coordinator of Appeals. It is important to note that the appellant only has a set number of days to file after receiving the order or written notice: 30 days for written notices and 35 days for orders. There is also a fee for filing an appeal, which will be set on the Notice of Appeal form. After receiving a complete Notice of Appeal, the Coordinator of Appeals will send a letter to the appellant and the respondent acknowledging that an appeal has been filed. The Coordinator will send a second letter once the date, time, and location of the appeal have been established. From there, the appellant and respondent will prepare their cases. Each party needs to put together an appeal brief that details the results they are seeking. Be sure to explain why this result is supported by the Safety Codes Act, its regulations, and any relevant codes and standards. Appeal briefs should also include supporting evidence. Depending on the subject of the appeal, this may include plans, communications, timelines, photographs, or video. Both sides can also call witnesses. You must let the Coordinator of Appeals know who you plan to bring so that arrangements can be made. Parties should submit their briefs approximately 4 to 6 weeks before the hearing date. The coordinator will distribute these briefs to everyone involved. The appellant will be able to read the respondent's brief, and the respondent will be able to read the appellant's brief. Members of the administrative tribunal will also review the appeal briefs and determine any questions they may want to ask during the hearing. Now that we have all our documentation in order, let's take a look at how the hearing itself will go. On the day of the hearing, both the appellant and the respondent will appear in front of the tribunal. One of the tribunal members will be designated as the chair. The chair will ensure that the hearing follows proper procedures and that everyone has an opportunity to present their case. The Coordinator of Appeals will also be present, acting as the hearing facilitator and providing guidance on hearing procedures. A technical advisor from Alberta Municipal Affairs might also be on hand to answer code-related questions. The technical advisor has specialized knowledge of relevant regulations, codes, and standards. Hearings are open to the public, so there may be observers present as well. However, the chair may excuse anyone in the room if needed. During the hearing, each party presents their case using the evidence and arguments in their appeal brief. There are opportunities to introduce new evidence, call witnesses, and ask questions through the chair. When the hearing is complete, the tribunal will dismiss everyone present so they can deliberate in private. Once the hearing has taken place, a final decision will be made. There are 3 possible results for an appeal. The order or written notice will either be confirmed, revoked, or varied. When an order or written notice is varied, that means that the tribunal has set requirements that are different than what was specified in the original order or written notice. The tribunal's decision is sent to the parties in the form of a council order within 60 days of the hearing. This decision is final and binding and can only be appealed to the Court of Queen's Bench on matters of law or jurisdiction. Thank you for taking the time to learn more about our appeals process. The Coordinator of Appeals is available to answer any questions you have. More information about our process can be found on our website.